So, for those who don't know me, I'm Marshall Dreyfus. I'm here this year as the Goodhart Professor, and it is my pleasure to introduce the actual speaker for today, which is my American colleague, Christine Farley. Christine teaches at American University College of Law in Washington, D.C., where for a while she was Associate Dean and teaches a slew of subjects, including trademark law, design law, art law, comparative IP law, and international IP. And writes in all of those subjects, as well as about geographical indications and copyright. She holds degrees from Binghamton University for her BA, University of Buffalo for her JD, and both an LLM and a JSD from my alma mater, Columbia University School of Law. Before teaching, she was a litigator at Rabinowitz Boudin in New York, where she worked on, among other things, the Havana Club case, which some of you know was ultimately a case decided in the WTO by the appellate body. She's a Fulbright specialist in IP and has been a visiting professor at law schools all over the world, including France, India, Italy, Puerto Rico, and has given lectures at numerous universities. But her real claim to fame in the United States is that she knows more than anybody in the entire world about the Inter-American Convention for Trademarks and Commercial Protection, an agreement that went into effect in 1930. It's still in force today. It's somewhat obscure, but it's a very important convention because it's self-executing, and we don't have very many self-executing IP conventions in the United States. And you see some of her deep knowledge of that treaty coming out in the paper that she's going to give today, in which she takes a historical approach to competition laws, unfair competition laws, misunderstood development. So with that, yeah, Christine.
Well, it's always nice, it's always easy to be an expert when you have absolutely no competition. So in the category of one, I'm it. Pretty easy. I want to thank you all for coming today, and I want to thank Rochelle and Lana for organizing this. I'm really delighted to be here. This is quite a treat to have time to talk about something that I have been very engaged with and to hear your thoughts and reactions to it. So I'm grateful. Thank you. So this is a paper in which I really tell a story, and I linger for quite a time in the 1920s. So to kind of make sure people will pay attention, I start with something that's a little bit more current, and that is this case that was decided in 2016 by a court in the United States. And even though I start the paper with this case, in fact, this case is already seeing some traction in other cases. So more recently, there was a case by another court of appeals in the United States, quite similar fact pattern that reached the same result, and there's still another case with the same fact pattern that's pending, in which the same arguments have been made. So this is the beginning maybe of something which I think is a good way to introduce the topic of my paper. So in this case, this is the question that was presented. When you have a Mexican trademark and somebody in the United States sees that Mexican trademark has never been used, has never been registered, is it available for that party to use and follow the proper procedures to register a trademark, or is there some protection that's owed to the foreign trademark owner? Ordinarily, we would say, because of the principle of extraterritoriality, the Mexican trademark owner has no rights. And that would be the case even where, as in this case, the U.S. party doesn't look very good, right? Is marketing their product as the one you know from Mexico, hint, hint, doing all kinds of things, which we might characterize as bad faith. Still, there's no right that the Mexican party had. So this case provided the Court of Appeals with this opportunity to really rethink unfair competition, right? What protection exists in unfair competition law? If there's such a thing, shouldn't it apply here? And the court basically came up with something that no other court in the United States has come up with before, and said the statute, in the section of the statute that deals with unfair competition, it doesn't actually say that you need to have a trademark in order to be a claimant. And so given that that's not a prerequisite, we see no problem in extending protection to this Mexican trademark. And I'll say a little bit more about that case at the end. So then I go back in time, and I just thought I'd give you two examples of the kinds of trademarks that were being litigated in the beginning of the development of trademark law in the United States. And, we're talking here about pharmaceuticals, loosely in that category of pharmaceuticals. And it's kind of interesting that there was so much litigation. Professor Bentley has written about old cases involving pharmaceuticals. But, the idea that there would be unfair competition claims when these very products, are literally going to cure everything, every ailment you have, right? So it's kind of a sketchy situation in making assertions of bad faith and unfair competition. But these were some of the cases. So diving back into it, I wanted to try to figure out, why is it in 2016 did the courts have, the judges have these basic questions about what unfair competition law is? Why was it that in that case, the Belmora case, the parties, and the United States made themselves a party as well, so there's a plaintiff and a defendant in the United States, the government, why did they not have ready answers for exactly what it is that unfair competition law protects? And so I went back to look at the origins, and one discovery I made is that this story we tell ourselves about the origins of unfair competition law in the United States is really a fiction, right? So we have this idea that there's unfair competition law, and a subset of that law is trademark law, and trademark law has developed, and unfair competition law has basically been the genus of that particular species all the while. There must be something in common with this. And in fact, the story is quite different. We have trademarks, and they are seen as initially a property right and very limited. And then in those gaps of protection, we then start to see the development of this new right of action called unfair competition. And actually, the development of trademarks went many decades, and after quite a period of expansive growth before anybody started really talking about unfair competition using that phrase. At first, it was called rights analogous to trademark, right? So there wasn't even a terminology to develop any real sense of that area of law. But unfair competition is the later developed doctrine, and it's really just to fill gaps. So this area of law developed as with trademark law. It developed quite quickly. There was a perceived need, and the economic situation and advertising, et cetera, caused there to be a lot of litigation in this area. But it developed with some constraints, and it had kind of peaks and valleys of acceptance and innovation in terms of the legal claims. So I have a couple just punctuated moments in this history to share with you. This is an interesting period in the development of the law, the kind of teens and just before the 20s. This is a very often quoted Supreme Court case involving trademarks. It was the red rose trademark for flower, which in the case was used by 3 different parties in 3 different places in the United States. And the court is kind of really wrestling with what rights go along with the trademark and why. And so we get this quote. Part of it is really interesting because of what the court says about goodwill. So here the court is enunciating this idea, which had been promoted by trademark lawyers at the time, which is the property isn't the trademark. The property is the goodwill that the trademark symbolizes. And so anything that would kind of appropriate that goodwill should be a violation. So that was an idea that lent itself to this kind of merging of trademarks and unfair competition. And the idea is basic, that the essence of the wrong consists in the sale of the goods of one manufacturer or vendor for those of another. So if you have a business, your business has goodwill. If somebody's confusing consumers, you should have a right of action, right? It's very simple. You don't need to worry about trademarks and property rights and, what are the bounds of unfair competition. It's just a really simple idea with broad application. And then this statement, the law of trademarks is but a part of the broader law of unfair competition, and that's the bit that always gets cited, but had never been expressed before and really doesn't have anything to support it, in fact. So my story is mostly about this fellow named Edward Rogers, and this is a book he wrote in 1914, so just 2 years before that case, titled Goodwill, Trademarks, and Unfair Trading, because the phrase unfair competition really wasn't uniform then. And he is one of the main promoters of this idea, right? There's a simplicity to trademark and unfair competition law, and it's this, right in protection of goodwill from those who would, through devious acts, confuse consumers. This gentleman is somewhat famous, although not as well known as he should be, because of his role in drafting what became the United States Trademark Act. He came up with the first draft in 1921, and he worked on that and pushed it up until its enactment in 1946. So along the way, he was also the delegate to the Pan American Convention. And not a lot of people in the United States know about this, so I doubt a lot of people outside the United States know about this, but there's this whole history of Pan American conventions, so the convention that he was a part of was the 1929 convention. That's the one I talk about. These are the parties to the convention. They're exactly the same parties today as existed in 1929. But this was a part of a much broader effort. And if you look at the time period, this was really kind of responsive to European, organized development of intellectual property treaties. So by and large, Latin American countries did not ratify the Paris Convention or the Berne Convention. And this was really an effort by the United States to create its own trade union with its own intellectual property treaties. And if one of you would like to become the expert on the Inter-American Convention of Patents or the expert on the Inter-American Convention of Copyrights, it is there waiting for you. There's nobody occupying that space at the moment, because the early treaties had all of them. It was a total intellectual property treaty. I believe in 1910 they started separating them out, but there were 6 conventions written. Each one superseded the last one, except for those in which there were parties who had not ratified the later one. So those are still in existence, and I have an example here. They took a bit of a different turn. They really kind of just parroted Berne Convention, Paris Convention, but they took a bit of a different turn following World War I. And the 1923 convention was the first one drafted by actual trademark experts, not just diplomats who had some idea about how to create this union. They were attempting to create a central registry in the Americas for American trademarks with 2 offices, one in Havana, one in Rio. And this is the first time we get this right, which is nowhere else in any treaty, which says if a mark is protected in one state in the Union, and you go to another state and find that that mark has already been registered, if you can show that the registrant had knowledge of the existence of the mark in any other state in the Union, you can cancel that registration and take priority. And that, in fact, carried on into the 1929 convention. So although Brazil is not a party to the 1929 convention, it is a party to the 23 convention, which means this should still be in effect between Brazil and the United States, which is kind of interesting that nobody's taken advantage of. The 1929 convention then is also drafted by trademark experts, although there's this confusing story about this team of 3 Latin American diplomats who took on a new draft just kind of hours before the delegates met. I've done a lot of research on these delegates that are the ones who are supposed to have drafted the text, and none of them have any idea about trademark law. They're quite legitimate diplomats. They went on to, have important posts in their country and were, delegates to all kinds of conventions all over the place. But it seems extremely unlikely that they had a hand in drafting it, or that they had, experts at home helping them draft it. It seems much more like this was drafted by the United States. And just to give you an example, the delegate from Cuba that was supposed to be responsible, he was at the very time working to ensure that Pan American Airlines had all access to Latin Americans' airports. And this was a means to exclude European carriers at the time. So there was that kind of diplomacy going on behalf of the United States. So what does the convention say about unfair competition? It says that acts calculated directly or indirectly to represent that the goods or businesses of a manufacturer are the goods of another are declared to be acts of unfair competition. The use of false description of goods, the use of false indications of geographical origin, and then further, the impression of being a product or article, commodity, originating, manufactured, or produced in one of the other contracting states. So even a broader scope for things that have geographic meaning. And any other act or deed contrary to good faith. So it's the kind of broadest statement of unfair competition that existed up to that time, right? Nothing like this appeared in any other treaty, in any of the laws of any of the states of the contracting parties. And I really feel like this whole treaty is an exercise in the creativity of the men who were responsible for it, right? They have, in their writings, lots of references to the plight of the American trader who expands to Latin America and finds that their trademarks have already been misappropriated by some local, and what they can do about it. And so this treaty was really an effort to provide those traders with remedies, and there was really no constraints on their creativity, right? There was no pushback from any of the other contracting parties. There were no other experts at the table. This wasn't going to apply more broadly than the United States and Latin America. And really, it was only going to apply in Latin America. It really wasn't ever conceived of applying in the United States. So Stephen Lattice, who's another trademark expert in the United States, although he's originally from Greece, wrote a book just before this convention. And that's where the first draft appears, is in his book. And that draft really tracks what became the convention. And he says, it's no use to conceal the fact that international protection of business relations in the American countries means, to a large degree, the protection of such relations of nationals of the United States. Right? This is just a market for U.S. products. There's nothing more. It's an indisputable fact that the United States is in a different position. And then finally, the latter countries rarely register any trademarks in the United States Patent Office, and the problem of protection of their trademarks in the United States is hardly existing, right? So just putting a period on that point about, this was for American trademark owners and not for any of the other countries. Press release about the convention says, it extends through Latin America common law principles of honest trading which have been enforced in the United States for 40 years under the elastic jurisdiction of our equity courts. So again, the idea that it is extending U.S. law into places where this had not been the norm, where there was not any unfair competition law. Language that might indicate that it's self-executing, states not yet having legislation shall apply to such acts, the Unfair Competition Acts, penalties from their trademark legislation and an injunction. Right? So here's how you can operationalize this text even when there's been no implementing legislation. And then, so that the treaty is ratified in 1929, becomes effective in the United States in 1930. This same gentleman, Edward Rogers, then is the lawyer for the plaintiff in this case, which goes to the Supreme Court. And he relies on the treaty in the case. He knows something about it, apparently. And the court ends up saying the Inter-American Convention is a self-executing treaty, and thus it became the law of the United States without the necessity for implementing legislation. So if there were any doubts about that is pretty clear, right? More than he could have ever expected, I'm sure. So we look at the timeline for whether it's self-executing. Just before the treaty, we have this Supreme Court case written by Justice Holmes, kind of reinforcing the idea of the supremacy of treaty law, even as in the case of conflicting state laws. So in that kind of approach to treaties, we have this treaty developed, and then we have the McCarty case where the Supreme Court says the treaty is self-executing. All the while, Rogers is drafting the United States Trademark Act, and so 6 years later, he at least would have had the very clear idea that that treaty was self-executing. That treaty is already the law of the United States. No matter what happens here in this bill, that is already the law of the United States. So I just put this here to show that just past the Lanham Act and World War II is when, in the United States, the reaction to treaties really goes in a different direction, right? There was a lot of reaction to civil rights being imposed on the United States coming from treaties. And so this is the beginning of a turn in which we don't see self-executing treaties in the United States. But prior to the Lanham Act is, I think, the period which is more relevant. So looking now at a timeline of unfair competition development, the Act was drafted beginning in 1921. Then we have Paris Article 10, which is the first quite expressive statement about unfair competition. I would argue the Inter-American Convention goes beyond Paris a few years later. In 1938, another important Supreme Court decision in the United States, the Erie, what's called the Erie Doctrine, in which the Supreme Court says that there is no federal common law, right? The common law, even when decided by federal courts, is the common law of the states, that the courts, the federal courts, have to apply state law, right? Now, up until 1938, all of the unfair competition law was federal common law. So this case, which has nothing to do with unfair competition, had the effect of undoing all of the common law in the United States in 1938, except for whatever protection would have been granted by the convention. And I just point out that there are two cases the same year, just months after this case, that Rogers himself was arguing again. And in one case, we've got the same justice writing the majority opinion. These are cases that are stretching unfair competition law and trademark law, and the argument wasn't made. I think it was just simply too early to make the argument that there is no unfair competition law. That was already the law of the case. And then just after that, we get the Bacardi decision saying that the convention is self-executing, and again, the Lanham Act just shortly thereafter. So what I focus on in the paper is trying to bring attention away from one section in the Act and to another section in terms of explaining what unfair competition is in the United States. So in what is Section 44B, as it was enacted originally, because there were some amendments over the years, first of all, it made explicit reference to the the Inter-American Convention. It mentions the Paris Convention and the Inter-American Convention explicitly, and says that beneficiaries of those treaties shall be entitled to the benefits and subject to the provisions of this Act to the extent and under the conditions essential to give effect to any such conventions and treaties, right? So in other words, if there's a protection in these treaties, those beneficiaries shall receive that protection unless there's something else in the Act which says they shouldn't have it, right? And in the case of unfair competition, there's nothing else that says they shouldn't have that protection. Further in Section 44, the Act says that there's a clause on unfair competition unfair competition, beneficiaries shall be entitled to effective protection against unfair competition, and the remedies provided by this chapter, the Trademark Act, for infringement of marks shall be available. And then finally, it has this really curious provision which says, citizens or residents of the United States shall have the same benefits as granted to treaty beneficiaries, kind of an effort to put U.S. persons on have the same advantages so that they wouldn't have lesser advantages, because of course there are things in the treaties that aren't in the Act. Makes it hard to figure out how that works, but that was the reason for it. And there's evidence that this was drafted by Rogers, right? Drafted by Rogers with the input of Gladys. In the legislative history, Rogers says, everything that we're obliged to do in our Pan-American Convention is included in this title. Well, I showed you the chapter on unfair competition. It's nowhere in the title, right? So the only way that it is in there is indirectly through Section 44. And then trying to explain why we have this unfair competition protection, he says, I do not want the finger of scorn pointed at us because they say, here, you have guaranteed to do certain things, but you've got to do it by statute. Now, how do you expect us to protect your citizens down here, definitely talking about Latin America, when you don't do it up there? Now, that's the point, and it's a pretty hard question to answer, right? So we have to save face. We have to incorporate the protections of this treaty in this manner. And then afterward, Lattice says, the Lanham Act, by virtue of these provisions, meaning Section 44, has changed the situation created by the Erie Railroad case, meaning that it has reinstituted all of the unfair competition common law, right? So these two gentlemen, at least, really thought they were doing something big in Section 44. There's a lot of evidence to support that. And so now I get to tell you about this case. People may know the name of the case, Stouffer v. Exley, but I was just thrilled to see what the case was actually about. It's about these sofas, these couches, and just to give you a little sample, again, talking about, these spurious goods that, there's going to be an unfair competition claim against. So Mr. Stouffer realized that most women lack time or facilities to get enough exercise to keep them slender. And he also knew that in many cases, strenuous exercise is undesirable. Isn't that a fact? So then this is talking about his invention, which just as a trademark lawyer kind of looking for issue spotting, he talks about it as the magic couch in quotation marks, and known as posture rest, but also known as the famous Stouffer system. So this is just wanting abuse, right? Because he's trademarked posture rest. He hasn't trademarked magic couch or Stouffer system. So people said, wow, that looks like a great product to save people time from exercising, and they marketed it as the Stouffer system. He didn't have a trademark, and so he brought an unfair competition claim just after passage of the Lanham Act. And the court, this went to the Ninth Circuit Court of Appeals, and the court there said, you have such a protection. You are a U.S. citizen, reading Section 44I. You have unfair competition protection, reading Section 44H, and found for the plaintiff without a trademark to assert under a theory of unfair competition. So that was exactly what Rogers and Lattice thought would happen. But that didn't happen for long. The Second Circuit didn't follow suit. The Second Circuit found that Section 43, this is a much later case, but it was the one that really put the nail in it. 43 is the location of unfair competition, not 44. And then the two cases that are more current that I'll talk about now. So that, maybe it was because Rogers died just after the passage of the Lanham Act. Maybe it was because it was too indirect and too indecipherable and too difficult. There was some pushback by the courts, but that approach that the Stouffer case took, that Rogers and Lattice thought every court would take, wasn't followed. And so Section 44 kind of died away, and we never hear of claims brought under Section 44 today. Instead, the claims are located in section 43A, which now says a false designation of origin, false or misleading description of fact, or false or misleading representation of fact that is likely to cause confusion is actionable. And this was the provision that the court relied on in the Belmore case to say, I don't see anything about a trademark, right? It just says any person who does this shall be liable in a civil action by any person who believes that he or she is likely to be damaged. It doesn't say by a trademark owner, right? So you have to show damage, you don't have to show a trademark. Most people don't know that that's not how 43A looked in 1946. So in fact, in one of the later drafts that Rogers wrote, 43A said that there shall be liability at the suit of any person doing business in the locality falsely indicated as that origin, which just shows that the origin in 43A was meant to be geographic origin, not source of origin in the trademark sense. It wasn't meant to be broad, it was meant to be specific about geographical indications. The redraft of 46 still said, shall be liable to a civil action by any person doing business in the locality falsely indicated. So this was the place where the Second Circuit started finding unfair competition, even though it was rather narrow. It was amended in 1988 to take out any references to localities, and that's given it a lot of room to expand. So the Belmore case that I started with was enabled by this case, which was also a Section 43A case by the Supreme Court in 2014. And there's so much litigation about this company, Lexmark, who makes printer cartridges, makes them very expensive, and has used every conceivable method of intellectual property to make sure that you pay that high price, right? So they have copyrights in their code, they have digital locks, they have patents, they have trademarks. Finally, this case went to the Supreme Court, even though there were copyright and trademark claims under a false advertising claim, because they accused somebody who was making substitute cartridges of false advertising. And so the Supreme Court decided in this case that how do we decide who can bring suit under 43A? We have to see whether their interests fall within the zone of interest protected by the statute, first step. And second step is we have to see whether their injuries are proximately caused by violations of the statute. And the Supreme Court, the Supreme Court said, well, in the case of the Lanham Act, it's very easy to know what are the interests of the statute because we have this lovely section that doesn't appear in very many statutes telling us what Congress intended to do. And it says Congress intended to protect against the deceptive and misleading use of marks in such commerce, right? And that is the phrase that the court relied on in the Belmore case, right? That was the intent, and here we have somebody using marks in a misleading and deceptive way, so the person has come within the zone of interest, and they can show injury because they're, losing sales in Mexico, and their customers who are from Mexico who happen to be in the United States are seeing this bad product and therefore think less of the mark in Mexico. So that was their injury. And so the Belmore case decides that there's a unfair competition claim here under the Supreme Court's analysis. But what they did, which was wrong, I think they're right in their general approach, but the mistake they make is this phrase that they rely on says the misleading use of marks. And there was no prior mark in Flanax, right? There was no existing mark in the United States. So this wasn't a misleading use of a mark, right? There may have been misleading statements made trying to connect the companies, but that wasn't a misleading use of a mark. That was only the US company's mark. There was no prior rights. A Mexican mark doesn't count as a mark in terms of Congress. So if the court instead noticed that and looked elsewhere for support to see whether the Mexican trademark owner was within the zone of interest, it would have to look here at unfair competition. And by the way, the phrase unfair competition only appears twice in the statute. One is in section 44 and the other is here. Or it would have to look here. So here it says to protect persons engaged in such commerce against unfair competition. And the Mexican trademark owner was not engaged in commerce in the United States. So they are not within the zone of interests under this phrase. And then you would have to look here at the treaties and conventions. And Mexico actually is a signatory of the Inter-American Convention, but never ratified it. So therefore, the Mexican trademark owner is not a beneficiary of the particular treaty right. So I think this is exactly, the court kind of came full circle almost to the point where we left off in 1947 with Rogers' technique, and they should have, for that reason, decided that this particular case was not within the zone of interest, but I think other cases actually should follow that and could follow this method to kind of reopen the Stouffer technique through this different way. So I don't want to end before I end. So what's happened is we've had this expansion of Section 43A. So not only do we have the kind of statutory expansion, but we have litigation expansion. And so I have this quote. McCarthy is the author of the, I think, 8-volume treatise on trademarks, which is cited by every trademark lawyer and every court who decides a trademark case in the United States. So he's like the living god of trademarks in the United States. And he uses, I'm so shocked to see this language he uses, protectionist expansion. So he's talking about this development of 43A, and he calls it a period of protectionist expansion, which some, although his article then goes on to be within that some criticize Section 43A as a loose cannon on the deck of the ship of intellectual property. So that's just to in one quote, kind of give you the sense of what's happened since the Stouffer case, right? 44 became closed, 43A became open. So I'm not doing all this work to try to find trademark owners another avenue of redress through Section 44. Instead, what I'm trying to do is to suggest that given these strange events and these wrong turns, we've landed here, which is not a good place to be. I think that, if the Stouffer line of cases had been developed, my guess is that, in a common law system, the courts would have found ways of constraining unfair competition, right? Is it unfair? Do you have to be in competition? What kind of injury do you have to show? I don't think in the 50s it would have developed to this extent. And so not only has this expansion happened in this way, but I think it's also been damaging not just for unfair competition law, but for trademark law. So we're definitely in that space where the two are the same. There's no distance between them. Everything which is a trademark violation is also an unfair competition violation. And what is a trademark violation anyway? You don't even need a trademark. So we're kind of in a no holds barred area. And I think this kind of curious story is in some small part to blame for the way the law has developed. So that's all I have to say. Thank you.
So why don't you think 43A will develop in the same way? I mean, now that we have this loose cannon rattling around the decks.
Yeah, so I think, I think there has been some pushback in that same period, but I think because it's not styled as unfair competition, there's always been this sense of, well, what's the limits of unfair competition, right? And so there's always been some when you raise a claim of unfair competition, when you suggest there's some legal right to protection against unfair competition, I think courts have always been a little suspicious of that, to say, like, where is this right coming from and what are the constraints on it? When you say I'm bringing this right in the zone of trademark law, right, then those things have gone away. So I think for that reason, 43A has expanded to this point, and it's not until 2016 in the Belmora case when we suddenly see, oh, and you don't even need a trademark, right? So before it was, oh, and everything can be a trademark. You think you've got a neat Mexican restaurant decor, that's a trademark. You know, you've got an interesting wine store display, that's a trademark. So everything could be a trademark, and therefore everything was unfair competition, but at least you had to have a trademark, right? I think had it been just unfair competition, I think especially the period in time when the courts were very skeptical, 50s to 70s, that's when the development of that common law would have occurred. Just maybe a Pollyanna guess, but I do think it's a bit different, expanding it under the umbrella of trademark versus under the umbrella of unfair competition. Yeah.
So on that, I suppose, and on some of the other things. Firstly, I very much enjoyed the paper,
Thanks.
but you say that the Inter-American Convention provision on unfair competition, Article 21 and 22 or something like that, is broader than Article 10 bis of Paris. Do you not think that it's broader than Section 43A, and what, if not, why not? So it strikes me that Section 43A at the very least requires confusion,
Yeah.
or likelihood of confusion. Some of those things in Article 21 seem to have very vague kind of conceptual groundings. So if the US had gone down the route of Section 44 and then indirectly relied on Article 21, I actually don't, I'm a bit not agreeing with your end point that you wouldn't actually have ended up in a worse position than we are now.
Yeah, no, I absolutely agree with you. I think 21, both of those statements can't be true. It can't be broader than Paris and less broad than 43A.
Yeah.
I think it is both broader than Paris and broader than 43A.
Yeah.
I agree with that. And I think that ridiculous breadth is what would have caused the courts to pull in the reins, right? I mean, it is true that you've got the basic 43A elements in there, what became 43A elements, but then the geographical indication stuff, but you don't even need a geographical indication, you know, some suggestion of another place, and then that last, you know, kind of catch-all in any unfair deed, you know, so I think it is completely broad and therefore would need to be reined in.
Yeah, so putting a cactus on something would have been within Article, well, my reading of Article 21, because that would suggest it was from Mexico.
Right. So the real question, and I don't really have an answer, is it already reined in because it's only available to treaty beneficiaries? So it's extremely broad, but it's only available to treaty beneficiaries. So that weird language of, oh, and US people get it too, I don't think they meant it to be broad. I don't think that's what they meant. What they meant, and so there's some suggestion in Rogers and Lattice's writing, what they meant was if a US person had a dispute with some trader in Latin America, then that US person could bring the treaty protections in US court. They didn't mean that two US parties who had nothing to do with anything in Latin America could bring the claim.
Okay.
So in that sense, they're putting the US party on equal footing had the roles been reversed. But I mean, you could interpret that language much more broadly, and then you get a whole unfair competition. Yeah.
Sorry, can I ask, Jennifer, is yours on that point? Because I've got the
It's
point
kind
that's
of
on that point.
related to, but
Okay, you go.
really?
If it's on that point, then yeah.
Well, it's on the broadness of Article 21, because if you look at unfair competition in the UK, which is generally thought to be passing off, where it differs from trademarks is it doesn't depend. It's not enough to prove confusion. You have to prove that the goodwill of the trader has been damaged.
Yeah,
And that's often evidence of confusion, but
Yeah.
it is not sufficient
right.
that you prove confusion.
Congratulations to you on that.
Yeah. So I'm struck
Jennifer
by.
might be against that, we never know.
Yeah. So what I'm saying is basically Article 21 doesn't tell you how you judge what is unfair. Either way, it doesn't tell you it's confusion, it doesn't tell you
Right.
it's goodwill. The Lanham Act seems to move
Yeah.
entirely in the direction of confusion being sufficient to prove
Right.
unfair competition.
Right.
And so I just kind of think, what happened to goodwill? I mean, Hanover Star
Yeah.
talks about goodwill, doesn't
Right.
it?
Yeah.
And this notion of passing off or palming off, which McCarthy would say actually is a surviving talk in the US and states and places like
Yeah.
that. So I guess I'm interested in where's some missing goodwill.
So
Where did that go?
I don't think that anything about the Inter-American Convention speaks to that question, but Rogers does, and Rogers had a role to play. He litigated so many important cases. He wrote so many things. He spoke to so many trademark lawyers. He really was the guy. When you read the legislative history of the Lanham Act, you get confused as to what role he's playing. You wouldn't read his testimony as if he's a witness. He is answering questions. He's telling people who's wrong and correcting. He's like holding court. So he was really a central figure, and I think he had something to do with that shift, which I think is a really interesting one, where it's not trademarks and passing off, and they're two distinct bodies, and they have different rules and different constraints. It's just, and I think that quote kind of captures it. There's just a muddling of the two, and that advances both trademark claims and unfair competition claims, because the need to be in competition fell away, the need to show any injury fell away, and it just became something that has secondary meaning and is likely to cause confusion. And those were the only requirements under unfair competition or trademark.
Which makes it very different to the UK
Yeah.
notion of unfair competition.
Yeah, and I think that's also, unfair competition in different countries means different things. So, I mean, it's a confused state globally, but everything about it has always been confused in the United States.
Yeah, and the same as a French lawyer. The problems are the same, the relationship between the trademark and unfair competition. But we have two different, we have the trademark, European regulation and French regulation, and we have unfair competition based on tort. We never refer to the Paris Convention, just an article of the Code Civil based on. So two different rules with two different way of reasoning. So we are more
Whereas Germany is really based on confusion. Unfair competition in Germany is based on confusion.
Yeah, and both Lattice and Rogers were aware of the developments in these other countries. They both were, delegates to other conventions and meetings. They were quite knowledgeable, so they knew, what were open avenues and what were constraints in other places. And I really feel like they kind of picked and chose and created this Frankenstein unfair competition, very, very knowingly.
Okay,
Yes.
So I was interested in your views, and maybe Rochelle's and Henning's, about section 44IH, and you sort of said one thing about it, but how it interacts with the notion of national treatment. So if you imagine Mexico is not in the Inter-American Convention, it's not signed but not ratified.
Right.
But somebody from Brazil can rely on that. And somebody from America can rely on it because the rights are extended to Americans.
Right.
The rights that are given to Brazilians are extended to Americans.
Right.
Is it not therefore also the case of under national treatment, a person from Mexico who's a party to the Paris, which is party to the Paris Convention, can also rely on it, and so that's a way for claiming to get there.
Yeah, no, I think I wish I were more certain about how Rogers and Lattice meant this to be interpreted. But I think from what I've read them to say, they do expect there to be these special extra rights for those parties. I think the reason they didn't follow it through and see that there would be a national treatment problem, because they were well aware of that constraint, was because they just never thought any of this was going to be litigated in the United States, right? This was really just a vehicle to litigate problems in Latin America. And maybe that's why it wasn't wholly incorporated in more of a direct way. And in that case, they were absolutely right, because if you talk to anybody from Colombia, if you talk to a Colombian trademark lawyer, they know this convention. This convention is
Columbia
used
with an O.
with an O. This convention is used all the time. By whom? U.S. trademark owners.
Okay.
Yeah, so all of the lawyers who represent major brands in Colombia rely on this treaty every day, not so much for the unfair competition, but for that, priority right if anybody knew of the existence of a right in another country. So that's what they wanted from it, and that's what they had from it. And to the extent they didn't perceive these problems down the road, it's because I don't think they really perceived this coming back up to the United States, which it has now, right? So there's one pending case right now involving a Colombian trademark, and somebody doing the whole Belmora thing just, with this Colombian trademark. And there, we'll see whether they find the convention to be applicable. But there have been some cases in the trademark office where Latin American trademark owners have successfully asserted the convention, and the trademark office says this is the law of the United States. It's a self-executing treaty, and so these Latin American trademark owners actually have priority over the first registrant in the United States. So so I do think it does set up a national treatment problem, definitely.
So, would you, if no one else has got a question, I'd like to know more about the Bacardi case from 1940, which I've never read.
Well, it's not really a trademark case.
Okay.
So it was about a law written in Puerto Rico, a protectionist law written in Puerto Rico that had the effect of damaging Bacardi's interests. And at that time, Bacardi was just moving into.
Bacardi was in Cuba then.
Bacardi's a Cuban company.
Okay.
Yeah. So it was definitely a foreign plaintiff, but it was a very powerful company. And Puerto Rico was a U.S. territory, so it was a local law constraining them in a protectionist manner that they relied on. There's nothing to fight that law except for this interesting new treaty that hadn't been asserted in the United States. So it was the first assertion of the treaty in the United States. Happens to go all the way up to the Supreme Court. Who could have predicted it? But I think it was a windfall for Rogers, who wanted to make something out of the treaty.
Sorry, I just want to return to about you speak about Colombian use of it.
Yes.
Well, I'm not Colombian, I'm Peruvian.
Okay,
to be
and
honest,
Peruvian uses it.
I've never heard of this
Never heard of it.
before
Okay.
in my life. We don't speak about it in Peru.
Uh-huh.
I'm not surprised we're part of it. Peru ratifies everything
Yeah.
from an international perspective. But I just wanted to ask a couple of things.
So
First-
one of the cases involved that I was mentioning in the trademark office involved a Peruvian mark.
Really?
Pardo's chicken restaurant.
Of course.
You know Pardo's?
Of course.
Yeah.
That's a very, very famous chicken restaurant.
But not a well-known mark.
That's my question, because we have the Andean Community Decision 486 that rules trademarks in Peru, Colombia, Ecuador, and Bolivia. And the provision there is that anyone anywhere in the world can claim a trademark in a country if it is a well-known trademark or a known trademark. For instance, if anyone, let's say, want to register Coca-Cola in Peru, they would not be able to.
Right.
But that would not be applicable to a Peruvian trademark in the United States where it's not known. But under this treaty, that I think it's underground somewhere,
Yes, it is.
they could eventually file a claim on the unfair competition
Yes.
there. Now, the effect of that would be just to avoid using the trademark or also grant them the registration of the trademark in the United States.
So there's, I didn't highlight it in this piece, but that text that I showed you from 1923 expanded into two articles, Article 7 and Article 8, which give you a right to enjoin the use and a right to cancel the registration and claim the priority of that registration which you canceled, which is an interesting additional benefit. So you're absolutely right that this completely would bypass any need to come within the doctrine of well-known marks, right? And in that one case from Peru, I think they would have been hard-pressed to argue that Pardo's is well-known in the United States. But because it's well-known in Peru, and the registrant in the United States was Peruvian,
Mm.
it was easy, without any evidence,
Yeah.
it was easy to say he has constructive knowledge of the mark in Peru, and that was all that was deemed necessary. And so it's a complete end run around well-known marks. And then the question back to Professor Bentley is, well, who does that end run apply to? Only to those 9 states, or does it apply more broadly to everyone? Wow. People will be citing my article at least. So. Yeah.
So you do mention passing off occasionally in your paper. What does it
Yeah.
mean for you in the American context, the US context?
So I mean, it was absolutely adopted from the British decisions, and I just keep it as passing off throughout my article, but it's also referred to as palming off.
Yeah.
And so I think initially it had some of the same constraints, but you know, a number of people, a number of American trademark scholars have already written on this area and tried to make sense of it. And having read the cases they cite and having read other cases, I just don't think there's any clean path through it to explain what happened, right?
Mhm.
You've got, you know, you do have some cases that say trademark is property, unfair competition is tort, unfair competition requires competition, unfair competition requires injury. But then you have other cases in which they don't say it, you know. So I think right from the get-go, there was a muddling of doctrine, you know, and I think it's maybe more indicative to look at the kind of facts of the defendant and how, you know, how kind of devious they were, and also the time period. So, you know, this is an interesting time period to look at in terms of moving from formalist legal theory to legal realism, and I think that actually plays into it quite a bit as well. But yeah, so it's not a clean doctrine that,
Yeah.
and I think that's in part why nobody knows what it is in the United States. Nobody really relies on it, but it's ever present nonetheless.
Yeah.
So these guys never represent anybody who is an entrant into the market. I mean, this is so pro-trademark.
Yeah.
And yet the trademark bar is not divided into, well, maybe it is a little bit, into trademark holders and other guys. They have no thoughts
Well,
about.
Yeah, I mean,
The other
if you
side
look
of
at
these
Roger's client list, it's all the really big companies. That's definitely who he's representing. But if you look at the legislative history, he got so much pushback from other witnesses, and those witnesses were themselves trademark lawyers.
Mhm.
And I don't know that they were pushing back on behalf of a particular kind of client, because they seemed, you know, I mean, there were no big trademark law firms at the time, but that was all they did was trademark law, these guys, and that's why they were invited to be witnesses. But they really, somehow it just didn't sit well with them that there would be such an openness, you know, and so they were particularly concerned with Section 44 and in invoking this, you know, unfair competition as this federal right. You know, that was the thing that they pushed back. And that was the reason for some change in 43A. They said, let's just, you know, cut that, you know, just completely scrap it, and let's massage 43A a little bit and get a little unfair competition in there, and we ended up with both. Yeah.
Has anyone tried to invoke this convention in, say, for example, the Inter-American Court of Human Rights or the Andean Tribunal of Justice?
I am not aware. I've poked around in the, you know, because the Organization of American States is in Washington. That was the building that I showed you, and they have an archive. I haven't seen anything there, but I don't know about the Andean community. One reason you may not have heard, well, in Latin America, the convention is referred to as the Washington Convention. It's never referred to as the Pan American Convention or the Inter-American Convention, always the Washington Convention. Ring a bell? No?
Not really. I mean, I've just looked at it. Like
Yeah.
in Peru, there's no Peruvian website. Speaking
Yeah.
of it, like, and there's no link for a Peruvian authority.
Yeah.
So yeah, I'm not
Well,
sure.
and even
But I
in
know
Colombia, where there seems to be a lot of use of it, it's really in the trademark office, right? This isn't kind of big notorious cases, but it's kind of quietly dealt with, these, you know, these preemptive registrations are dealt with very efficiently.
Yeah, maybe we don't have that
Yeah.
much
Yeah.
in US.
Yeah, just picking up on Alex's question, is there any dispute settlement procedure under those conventions? Or is there any mechanism for ensuring compliance? Is there any issues of compliance that the US was unhappy about how, say, Latin American countries had or had not, currently in Peru not very much, implemented that?
No, part of the reason why nobody knows about this treaty is because there really hasn't been much said about it since that time. So, Lattice, until he died, kept writing. He always included it when he was talking about international trademark law. He included this treaty, but there really wasn't any follow-up at all, even on the part of the United States. There were no further conventions to kind of relook at the patent convention or the copyright convention or the trademark convention. It kind of just ended there. I think world events maybe took over.
I guess if it's part of domestic law to some extent, would you argue that seemed to be, depending on how much you consider self-execution still a valid doctrine in the United States, but to the extent it is there or elsewhere, you could try to make an argument that the protections under the convention could even be something which, if you look at trademark as an investment in an ISDS case, in an investment case, you could probably also rely on the protection available under that convention, perhaps.
I think
So
that's
that
right.
might be even another forum where you could litigate those protections.
Right. Yeah, and that feeds into my sense of being conflicted. I find this all very interesting, but at the same time, I don't want to write a blueprint for somebody to bring all these cases. But why haven't they? I don't. I'm just kind of shocked. I ended up talking with the attorneys who were bringing the case that I mentioned about the Colombian trademark in the United States that are relying on it in district court, and they were just so bewildered. They had never known about it. They couldn't wrap their heads around it. Does it say what it says? It seems like it. Anyone else?
Are there a lot of treaties like this in the United States, do you think?
No.
There's agreements that are just sort of, they were entered into a long time ago and nobody talks about them?
Outside of IP law, I can't say. I don't know. Maybe. Maybe there are a bunch of, but what's interesting, and the reason I can't understand why this one is forgotten is because there's not a lot of noise in the IP trademark space, right? It's not like there's so many treaties, we can't keep track of them. And I should say, there was a protocol for this treaty as well. And the protocol created, and they actually did establish a central registry in Havana for all inter-American marks. Guess who registered their marks in that central registry? The United States. Right? There was no other registrations from anywhere else, but they created that. There was a central registry, and then it became disused, and so the United States formally renounced the treaty, the protocol. Right? So there was a treaty and a protocol. They renounced the protocol. So that, to me, suggests that this is very much in force, right? The United States has proven that they know how to renounce it if they wanted to renounce it. They chose not to. The treaty is still very much in force.
But you can access the register still, because you said you know who registered.
So I don't, it's in Havana. I could ask, but there were reports. There were certain, I saw certain reports of various years that they reported on the trademarks that were registered.
Do you think Castro would have taken to this in a big way?
And then he registered to nationalize everything that's on it.
Yeah.
Little blueprint.
Or maybe we should just thank Chris.
Do I make an announcement?
Oh, yeah, you make your announcement.
Yeah, okay, so, so just want to tell everyone that Dr. Henning Carr is giving a talk at Wolfson College tonight at 6 o'clock on automated copyright by platforms, designing Autonomous Global Norms. And it starts at 6, but there's wine and juice and nibbles beforehand. And so any of you who feel like coming and listening to that, you'll be very welcome. And it's at the Gatsby Room at Wolfson College. So tell you about that, and let's thank Christine for talk.